the Michigan Rental Agreement. In this video, we will tell you about the most noteworthy aspects of rental agreements in the state of Michigan. What is a rental agreement? A rental agreement, or a lease, is a document that outlines the arrangement between two parties regarding a property rental. The one who's paying rent is called a tenant, while the owner of the property, who lets the other party use it under certain conditions, is called a landlord. The parties may also be called a lessor and lessee. Typically, a rental agreement lasts for 6 or 12 months, with rent being paid every month or every week. There is one federal disclosure that works for all lease agreements in the United States. This is called the lead disclosure, and it requires the landlord to tell the tenant about all known lead paint hazards. They should also provide the state-approved version of the pamphlet, Protect Your Family from Lead in Your Home. However, this requirement applies to not all types of residential dwellings. Required disclosures. Apart from the above-mentioned disclosure, the landlord should also disclose to the tenant the names and business addresses of the people who own and are authorized to manage the rental unit. Along with the lease, the landlord should also give to the tenant copies of the inventory checklist both at the commencement and termination of occupancy. The checklist should detail the condition of the rental unit for which a security deposit is required. What is also required from the landlord is including in the rental agreement the notification about it complying with the Truth in Renting Act. The landlord also needs to send to the tenant a written notice on protection from domestic abuse, which allows the tenant with a certified proof of domestic violence victim status to be released of their lease obligation. Instead of sending such a notice, the landlord can include such a provision in the rental agreement. Security deposits. According to the Michigan general laws, the maximum security deposit cannot be more than 1.5 times month's rent. The landlord shall return the security deposit within 30 days after the end of the tenancy. The landlord can use the deposit to pay unpaid rent or repair any property damages caused by the tenant after sending the tenant an itemized list of damages and their costs. If the landlord fails to return the security deposit, the Michigan laws make the landlord liable for double the amount of the security deposit retained. Landlord access. The Michigan laws do not set a specific time frame for an entry notice for the landlord before accessing the rented apartment to inspect the premises, make repairs, etc. However, at least a 24-hour notice is always recommended. Termination of agreement. In case of year-to-year tenancy, a notice in writing shall be given at least 1 year before the end of the lease by either of the parties. For a month-to-month tenancy, a notice in writing shall be sent at least 30 days before the termination of the lease. If a lease is week-to-week, a written notice shall be sent at least 7 days before the end of the lease. Notices for non-compliance and non-payment. If the tenant fails to pay rent, damages the property, threatens violence, or poses a risk to health, the landlord should send at least a 7-day written notice to pay or quit. If the tenant violates other terms of the rental agreement, the landlord should give a 30-day notice to remedy the violation or vacate the premises.